going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. Happy Friday. Friday. We made it to the end of another work week. Well, at least most of us have. I work on the weekends, so it's not the end of my work week, but you guys know what I'm trying to say. Anyways, I hope you guys did have a great week and you have some great weekend plans. You guys want to watch some court? I want to watch some court. Let's watch some court. What do I have tonight? Let's see. We're starting with Judge Middleton. We have some Judge Washington. Let's see. Judge Simpson stops by. Judge Shackelford. Judge Satterfield. That might be it. I've got two different sovereign citizens and then a bunch of idiots, or a bunch of idiots that just happen to be a few of them. So, you know what? I'm going to stop talking. Well, let's just watch some court. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Thank you. All right, Mr. Benek, I'm going to unmute your microphone. Can you hear me?
Hear you fine.
All right.
Oh, you hear me good. Okay, sorry.
Okay. This is New Res LLC versus Jared Michael Benek on Electric Court in Sturgis. Attorney Mirella Albu is here from the Trott & Trott Law Firm in Detroit on behalf of New Res LLC. This property was sold at a foreclosure action last August 22nd. And this probably has been in the works for several years. You have 180 days to vacate, or they can bring this action. They've waited well beyond that. And at this point, it's the bank or this New Res intentions to take possession of this property and probably sell it. What's your position, Mr. Benek?
Okay, the only position I really have is we started out, my son, I'm the father, and we started out with a payment plan with them at 3-point-something% rate interest. And they never told us anything. After about 2 years, it started going up and he got behind. It was like a package a kid has kicked out. We couldn't pay. There's no way you could pay and keep up. And on top, he lost his job and he tried to fix all that too. So we went through.
So are you a co-signer for your son?
I'm just speaking for his behalf because and I'm really tired. I take care of most of the stuff in his house. He's like almost sleeping here in the chair. I can show you him if you want to see him.
All right, just a minute. What's your name?
Michael Benek. I'm his father. I've talked to them before.
Just a minute. Mr. Benek, do you have a law degree?
No, I do not. I don't have to have a degree. Just freedom of speech.
Waking up. So, I don't need to talk to him. I need to talk to him.
Well, he would like to have a statement. I guess I can't speak in his behalf.
No, you can't. You need to have a law license to represent somebody in a legal action.
Well, I guess I'll have to go to court then, won't we? All I'm doing is just trying to tell him we're not fighting over the house.
All right, we already
have it signed. We don't care.
Let me talk about where we are here. Okay. Your son had a variable rate mortgage and his rent went up, or his payment went up, and he wasn't able to make it.
They doubled it.
This is my turn to talk. This is my turn to talk. So he hadn't made the payment probably in several years. Probably it wasn't made at all in 2024 and probably part of 2023. The house was foreclosed on last August. So this didn't sneak up and bite you in the ankle.
No, we didn't. But we didn't get any. We could talk to him, sir.
You got a notice from the sheriff that your house had been foreclosed on. So they can't do it unless you get notice. They post it on there. So you've lived there at least since August, September, October, November, December, January, February, March, April, and
Okay,
soon
you're
to be
right.
May
You're right. I agree
without
with all that.
making any payment.
Yeah, I
So
agree with
your
all that.
son has the benefit of free housing. So I want to talk to him, or I'm going to default him.
Here you
Sitting
go.
there sleeping in a chair. Wake up, dude. You're about to get kicked out of your house. Are you Jared Michael Benek?
Yes.
All right. The mortgage company wants your house back. And they have asked you to move. Have you made any provision to move?
I've been having a hard time getting money to move.
Yes, well, you've lived there for free for 2 years. So theoretically, no one does. You should have a big pile of money when you didn't make your house payment to move somewhere else. But this proceeding is an unpleasant one. It is what property owners and landlords do to get their tenant out. The tenant would never move otherwise. You've known since last August that they want you to move. We're now almost in May. So I have to continue this matter. I'm going to continue it to May 2nd at 3 o'clock. Does that work for you, Ms. Albu?
Yes, Your Honor.
All right. Now, this is the end of a long process. They had a sheriff's sale last August. And you had 180 days to redeem the property.
Is Abby
March, which would have been March. And now you haven't redeemed it, so they're asking you to move out. They want to take possession of the premises. So if they get what they asked for on May 2nd, I would order that you be out of the house by May 12th, which is 17 days from now.
Yeah.
All right, so we'll talk about this further. Now, I read the advice of rights, but you were sitting there in a chair. I don't know whether you were paying attention or not, but what I did say is you have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. So I sent you the information with legal aid's name and number on it. You could contact them. But I don't really know that you have a defense. You haven't made your payment. The bank foreclosed on it. 180 days passed and you didn't redeem it. And now they want the property back. And so it's a tough situation. We do this every Monday and Friday, and people are struggling. But have you made any effort to find a place to move to?
What do you ask?
Any effort to find a place.
No, we just started because we didn't get informed that they sold the house. I'm trying to tell you, there was no communication between these people. They came to our door and wanted to give us a favor to go to court here. It's the only time we ever spoke with them. But I mean, he doesn't know what to say. He's a young guy. I was helping him get the house. I use even my own money. I'm going to die soon, so I don't care. But all we're trying to do is just leave the house, give us 30 days or a little bit more, and we'll move. My daughter was buying the house.
We can talk about that next week. Sergeant Bruce Morse posted this on your door. It was published in the, I think, Three Rivers Commercial back in June of 2024 that the sheriff's sale would be in August. They posted it on your door. You didn't show up at the sheriff's sale. It was actually adjourned from July 11th to August 22nd. So they did post it on your door. And then you got notice with this when they served the notice to quit on you several months ago. But you do know you haven't made any payment on the house probably in 2 years. So they're foreclosing on that. So we'll talk about that. You may ask for 30 days or something, and they may be willing to grant that. Ms. Abu can check with her client and see what consideration they can give. But I would suggest you start making plans to move. The date would be May 12th. If the plaintiff agrees, they could give you more time than that. So we will do this again next Friday at 3:00.
What happened to have you in the picture for buying the house? Whatever.
Do you want to ask for more? What did you ask, another question?
No, we just thought that since my daughter took over the contract and he's buying it, that it would clear his record and wouldn't have to mess with this at all because she's buying it.
I don't know about that. So your
That's
daughter's
what- yeah,
buying the property?
She
From Shell
physically
Point?
told me she already has agreement and stuff and that she's buying it. I can get her out of here next time you want, but
Well, they
And we-
haven't got possession of it yet.
and she
Who's-
said,
what's
I
your
can just let
daughter's
you
name?
guys move and you gotta move, but she wants us out in a few months anyway, so we were trying to do that. That's what we started working on.
What's your daughter's name?
Abigail, Butts. I think she's still got her original last married name. She hasn't got rid of that yet.
And she is purchasing it from who?
And she says she's got the bank approved through some bank to buy it, and it was already approved that she was buying it. She's moving.
All right,
She
well,
said
let's
she
talk
took over
about
stuff
that.
here, and I took care of her kids for 3 months and didn't get paid
Well,
a dime. I'm trying to help
They
her,
can't,
but-
they can't sell it until they take possession of it. They don't have the authority to sell it right now, so she may have a bank.
All right. You want you want my reaction? You don't want to hear my reaction. I have been laughing ever since this guy said hello, and I don't like making fun of people. Not for things that they can't control, and you can't control what what your voice sounds like. But when he first came on camera, I don't know what I was expecting, but I was not expecting the hello. I was not expecting that, and I've been laughing for 5 straight minutes. That's why I've been quiet. I'm gonna go laugh to myself. This one's almost over.
Ready to loan her money to purchase it, but it isn't for
Oh.
sale yet.
So
All
we
right.
waited that long because we thought she was doing something through there. Oh my God.
Okay,
Okay, well, I
All
guess
right,
we're
we'll
lost.
talk
too,
about
so
this.
What we're gonna do is just try to move as soon as we can. I don't care
All
what's
right.
going on. This is all a bunch of crooked shit. We're just gonna get out of it. We're gonna move, and if you don't get his record
Sir?
straight, what?
Sir, I don't want you to
sorry.
curse on the record. And it isn't
Oh,
crooked. Your
did I
son didn't
curse?
make the payments.
Oh, I
They
said
gave him
shit.
notice.
Oh.
You've been living there free for 2 years and somehow the banks are
but
crooked.
We were trying to move. We're trying
We'll
to
be
do this
back
thing.
next
You know what
week
time is
at
like.
3:00. You can rant at each other there in the apartment and I'll see you next week.
All right, thank you,
There
Your
may
Honor.
be some crooked stuff going on, but I don't think it's the bank. All right, Ms. Albu, thank you. I did most of the talking and you just had to sit here and listen to me, but we'll see what we can do next week. And if you check with your client, they can give them some additional time to vacate.
Yes, Your Honor.
All right, thanks a lot.
Thank you.
All right.
All right. Yeah, that was the first one. Yeah. Judge Middleton wasn't wrong. He did most of the talking. I didn't even cut in. I cut in once because you guys were asking. Yeah, I don't know what it was about his voice, but I could not stop laughing. Yeah, living there for 2 years, not paying rent. Yeah, I don't know what the dad is trying to do. Get him more time. I mean, if your daughter's buying the house, buy the house and give as much time as you want. I don't know. I don't know the answer to that. It's a weird situation. And I do agree with Judge Middleton. There might be some crooked things going on, but it doesn't have to do with the bank. The daughter buying the house. Anyways, let's go. Let's move on. What do we have next? Oh, we're jumping to Judge Washington's courtroom where we have an update. We have a House of Buckner update. I was debating even putting this in here because yeah, I wasn't too happy with what happened today. And yeah, you know what? Let's just play it. Judge Washington, House of Buckner. Let's go. No, you didn't. No, we're this is a when you're in the chat, it's a dog free zone tonight. Just tonight. I watched your video. I don't need you talking about dogs tonight, Shane. Please. Please.
We'll call the matters of Lawrence Buckner, 25S00.
Oh, everyone else can talk about dogs, just not Shane. Shane is not allowed to talk about dogs tonight. He can talk about dogs all he wants to tomorrow, but just not tonight. And if anyone watched this video from earlier, you know why.
102 and 103.
Tiffany Woods for the people.
Good morning, man. Please, this honorable court, Kareem Johnson, on behalf of Lawrence Buckner. Mr. Buckner, please unmute yourself, turn on your camera, state your name.
Lawrence to the family of Buckner.
Thank you.
And Your Honor, Assistant Public Defender Davila Balls on behalf of Mr. Buckner in the 102 matter.
Thank you. We're here for a final settlement conference on both of these matters.
That's correct, Judge. On the 102 matter, that's Deputy Jordan Irbies. He was on this morning, but he's teaching. I've been in contact with him over email, Judge, and I do have his bad date, so we're able to proceed on that case. And then in regards to the 103 matter.
102 on a malicious use, you're able to proceed. How can you, I'm trying to understand what you're saying.
The victim, Judge, is Deputy Jordan Irbies. He was on Zoom earlier, but he's teaching a class today, Judge. I have been emailing him back and forth. I do have his bad dates, and he does want to proceed on that case. And then in the other case is 103 case. The victim in that case, one of them is a 3-year-old child, and I believe the mother is going to log in. It's for Serenity Dillon. Jacob Dillon and or Serenity Dillon, and I think
The victim.
Mr. Buckner, be quiet.
yes, she was in the vehicle, Judge. Jacob Dillon and Serenity Dillon, and the mother is.
Oh man, Mr. Buckner's attorney coming in hot. No, we are not playing your game today. You are not going to say a word. That's one of the reasons why I didn't really want to play this tonight. He says a few things, but not a lot. This is just a procedural, but it's keep everyone updated on what's going on. He's out of prison or out of jail. Sorry. He wasn't in prison. He's out of jail. I wonder if he's back in front of a car that that attempted to run him over and that shot him 9 times in the head. Yeah, that's this guy.
Supposed to be logging in because she's a child.
All right, what name are you asking for again? Mr. Buckner, please mute your device.
Serenity Dillon's mother.
What is her name? Do you know it?
The victim advocate's name.
Okay. Is Serenity, did you say Serenity Dillon?
That's correct, Judge.
Serenity Dillon's mom present? If so, please mute the device and state your name or that you're her mom or his mom.
She's in the waiting room, Judge, and her name is Kimberly Burke.
There's no one in the waiting room. I'm looking right at the waiting room.
Oh, that's what.
Yeah, he only sits in a wheelchair when he's in jail. It's the only time he needs it. Something about jail that just really messes him up, and he needs it. I don't know what it is.
You were the wrong Zoom. There's no one in our waiting room.
That's what she's saying. If she's in the waiting room, maybe could we pass this just momentarily, Judge? Because I know we've been in contact with them all morning.
Okay. What did you say, Ms. Woods? I'm sorry, I couldn't hear what you were saying.
We've been in contact with the mom all morning. I'd ask just to pass this briefly to find out where she's in the waiting room, on what Zoom.
All right, I'll come back to those matters, Mr. Johnson and Mr. Leboff.
Thank you, Judge.
14B District Court is back in session.
All right, I do want to make one point. So he has 2 attorneys because he got multiple different cases. So he has 2 attorneys. One of them filed a motion to withdraw about a month ago, and they never ruled on his motion. Maybe it happened not on YouTube and it wasn't on the record, I don't know. But they never ruled on it. But he filed a motion to withdraw as counsel, but he's still there a month later. No idea what happened. Maybe it was denied. I don't know. I just, every time I see Attorney Johnson, I'm like, why is he still here? He still shows up at every appearance.
Court will call the case of the State of Michigan versus Lawrence Buckner, 25S00103, as well as 25S00102.
Tiffany works for the.
There you go. He's in a car. So it's officially a Zoom court now.
Good morning, may it please honorable court. Kareem Johnson, on behalf of Lawrence Buckner, as the 103 matter.
And Assistant Public Defender Davia Liba for Mr. Buckner to the 102 matter.
Thank you.
Mr. Buckner, can you say your name, sir?
Lawrence of the family of Buckner.
Thank you. All right.
Judge, the first case, the 102 matter, is Deputy Jordan Irbies, who is on Zoom earlier this morning, but is in a training class.
I remember he's here. You're ready to go.
That's correct. And then the mother for the Dylan, let me see, I had her name. Kimberly Burke.
Kimberly Burke, is Kimberly Burke present?
We would be unable to proceed in that case, Judge, but we can proceed in the 102 matter.
And Your Honor, in the 102 matter, we would be waiving to bench.
Your Honor, as to the 103 matter, we be requesting a dismissal without prejudice.
All right, let's start with the 103 matter. As to the 103 matter, the people are unable to proceed. The court will grant the motion to dismiss. It is without prejudice, so they could reauthorize it. All your bond conditions are over now. Please do not violate any of the bond conditions.
Miss Washington, you said the guy said Lipo. He said something about waving it over to a bench because he don't want to hold the testimony today.
That there's no testimony going to be taken today, Mr.
Oh, this is just a scheduling hearing,
Yes.
right?
And
Okay,
Mr. Buckner,
I
you
didn't
did.
understand. Okay, thank you.
And Mr. Buckner, you did previously indicate me you wanted to set for a bench trial. Is that still the case?
Yes, but I thought this was something else. You know what I'm saying? I don't, because the different classes of the development of the situation for the situation.
All right.
I'm glad I'm not the only one that struggles with words. Different classes of the different situations of the situations. Oh, I missed a word there. Different classes of. Anyways, whatever he just said. Yes. Yeah. Words are hard.
So case number 103 is dismissed. As far as case number 102 is concerned, the people are able to proceed. You're entitled to have a trial by a jury, at which time 6 people would decide whether or not you committed this offense. It's my understanding that you're choosing to waive your right to have that, and you want to proceed with a non-jury trial or a bench trial, which is the same thing. I'm the judge of this court, and I'd be the person making the decision on your behalf in this case. Is that what you want to do, sir?
Yeah.
All right. Do the people waive as well?
Yes, we do, Judge.
Is the May 13th date a good date?
Your Honor, that would work for the defense. I'm not sure if the two trials may conflict.
I don't know what that. If you guys are trying to set my schedule again, please don't.
Yes, Your Honor.
Judge, I have the unavailability for Irby's right here. What date was that again?
May 13th at 2.
That works, Judge.
May 13th, 2025 at 2 p.m. Bond is continued. We'll see you then, sir. That's the day we take testimony.
Okay,
Thank you.
thank you.
And Your Honor, would this also be on Zoom?
Yes, it would be.
Thank you.
Thank you.
All right, May 13th, we're going to get a hearing. May 13th is Cincinnati Day for anyone interested. 513, it's the area code for Cincinnati. And I don't know why I felt the need to say that, but now you know. All right, so I'll look out for that one. We got a couple weeks before that. All right, let's just move on. I don't even want to talk about the family of Buckner. I think we're going to Judge Satterfield next. We got a real SovCit next, not the one that just pretends. Nope, not yet. We're gonna start with Shackelford. Wrong S name. This one's just funny, and Judge Shackelford even makes fun of this guy. It's funny, but Satterfield's next.
Okay, Detective Hinojosa, which one are you here on? Or both?
I'm here for Mr. Pablo Calderon, and then Detective Chamberlain has the other one.
Okay. All right, this is 25116.
I am so sorry, Michelle. I am so sorry. I did not call you out. I've paused the video like 5 times and I didn't shout you out. I am so sorry. That was not intentional. Thank you so much for the 14 months. I do appreciate it, and I am glad you're part of the family too. And it is great to see you. I'm happy that you joined us tonight. Thank you so much.
3, the state of Michigan versus Pablo Calderon. Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record?
Detective Mario Hinojosa.
Have you read the type complaint that was filed with the court?
Yes.
Are the facts stated in the complaint true to the best of your knowledge?
I always have fun doing the live streams. I was just annoyed with Buckner today because I sat there for, I don't know, scheduled at 9:30. He didn't go on till a little bit after 11. So I was waiting there for an hour and a half, and then there was nothing. So I was like, no, you got to act up. That's why I was waiting. And yeah, nothing happened. So I'm just frustrated with him. They didn't let him talk today. That's it. That's all.
Belief.
Yes.
Can you state the facts that support the issuance of the arrest warrant?
On April 24th, 2025, at approximately 3:17 a.m., Corporal Peak was in the area of Inkster and Ecorse in a fully marked vehicle when he observed a gray 2012 Dodge Journey traveling southbound on Inkster. The vehicle did not have an operable lighting over the license plate to illuminate the license plate at nighttime. Upon observing this, Corporal Peak initiated a traffic stop on the vehicle. Upon approaching the vehicle, Corporal Peak identified the driver as Tyler Sloan via his Michigan driver's license. A lien check of Sloan revealed numerous misdemeanor warrants. Sloan was ordered to exit the vehicle and was detained in the rear of the patrol vehicle while dispatch checked other jurisdictions for the warrant. While dispatch checked the warrants, Corporal Peak.
The defendant was going to be here in a second. I kept the reading of the warrant on the video just so you could hear Judge Shackelford make fun of the guy. And then we'll see the defendant right after this.
Asked the front seat passenger for his name and he stated Francisco Calderon, provided the date of birth 2/12 of 94. A lien check of Calderon revealed no record but a Third Circuit felony warrant for Calderon. Upon observing the driver's license and verifying his identity as Pablo Calderon. Calderon was ordered to exit the vehicle, which he did, and was placed under arrest for his felony warrant. With the consent of Sloan, officers conducted a search of the vehicle and located an Adidas backpack in the trunk, which was open to the entire passenger compartment. In the backpack, Corporal Peak located 3 bags of suspected methamphetamine weighing 4.49 grams with packaging. Also in the backpack, Corporal Peak located a notebook with the name Pablo Calderon written on it. The methamphetamine and backpack were seized as evidence. Sloan was released from the scene with a traffic citation, and Calderon was transported to the station. The narcotics were tested using a true narc system, which came back positive as methamphetamine.
Okay. Did you sign the type complaint before you sent it over to the court?
Yes.
All right, let the record indicate I find probable cause to believe the accused committed the alleged offense, and I'll therefore issue the warrant. Keeping a notebook with your name written on it in the backpack with your drugs. It's like allegedly. That's an interesting fact. Yeah.
Yep.
Okay. All right. He's in custody. Anything on bond?
Well, whatever the court recommends, Your Honor.
All right. Thank you, Detective. Do you?
All right. Allegedly. I don't know. What I was laughing at that when he was reading it, and then I love how Judge Shackelford called him out. So I was like, all right, this will go perfect for the SovCits and idiots. All right, now we're about to see this this idiot. We're about to see him now.
Who are we seeing next?
Next is Mr. Calderon, ma'am.
Okay, thank you. Hello, sir. Can you hear me okay?
Yeah.
This is 251163, the People versus Pablo Calderon.
Good afternoon, Your Honor. James Guzecki on behalf of Mr. Calderon. Waive reading of the complaint, stand view. Request a court-appointed attorney. There's also order to preserve evidence. I believe there's no hold, no bond.
There is. Okay, sir, I've signed the request for court-appointed attorney as well as the ex parte order to preserve evidence. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. If you can't afford an attorney, one will be appointed to represent you at public expense. You have 2 dates coming up within the next 21 days. The first is your probable cause conference, and that will occur on May 5th of 2025. And you can appear at that hearing via Zoom. Following that, you will have a preliminary exam, and that will occur on May 12th of 2025 in person at the 23rd District Court. At that hearing, the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. Sir, you have warrants out, including a no bond hold. So, and given the allegations here, I know there's no allegation that you were operating the motor vehicle, but certainly concerning. You have a $30,000 10% bond. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot possess or have access to firearms or other dangerous weapons. You cannot consume alcohol, consume or possess alcohol or illegal drugs. You could be subject to testing on demand, and we will see you on May 5th for your first court date. We're all set.
She didn't even let him talk. They didn't even confirm any information of the guy. I wanted her to make another joke. No more jokes. Yeah, if you're going to allegedly put drugs in a backpack, don't have them right next to personal items with your name on them. Not a good idea. Annalise, hold on. Let me Let me start from the beginning. I'll get right back to you, Annalisa. Jedi, thank you so much for the super chat. Found this so Rich has something to do. Thank you, Jedi. I appreciate it. Tharina, how is this, Rich? Publish me. Thank you, Tharina. Legal Fiction. Who's Rich? I don't know. No, so some random guy that's been hanging out since about the time I started my channel. He just keeps coming back. We like him though. Don't really know him. I'm just kidding, Rich. Thank you, Legal Fiction. Annalisa Molina, very generous super chat. Thank you so much, Annalisa Molina. Still my favorite name to say on the internet. Thank you. I do appreciate it. Congratulations. Thank you. Thank you. And Liberty Bell. I wish I were rich. Thank you, Liberty Bell. I appreciate it. All right. What do we? I think now we're actually going to Judge Saddlefield. We got the angry soft sit. Yeah, we got an angry soft sit. Yeah, that's all I'm gonna say. If you haven't seen this yet, you're in for a treat. If you have, you're still in for a treat. Let's go.
Got here with Mr. Seahigh. Looks like it's a new domestic case involving Shannon Seahigh. I'm not really sure why he would have been allowed to have any contact with her whatsoever, given all of his case history with her. Mr. Seahigh, it looks like you're back in jail on new charges. There's some of the same similar.
Judge.
Yep.
Born on the record, I reserve all my rights under the Uniform Commercial Code, specifically UCC 1-308.
Okay, I'll note that. I'm going to quickly go over the charges with you. You should receive a copy of them and you can just read them yourself. But count one, you're charged with threatening Shannon Seahigh on or about the 23rd day of April 2025 in Butler County, Kansas.
That never happened.
They've not communicated what the exact threat is, but they've alleged that you threatened to commit violence or communicated with her with the intent to place her in imminent or immediate fear.
That's not true.
Okay, so I'm going to enter not guilty. If convicted, 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. Has to run.
Judge, since this is the first court date, I would like the evidence to be presented for it on the record.
Okay, so what happens is, and I don't want to read it out loud, but the judge assigned will get an affidavit. Well, yep, I'm assigned. I will get a probable cause affidavit for this arrest. And if there's probable cause, which is something more than a mere possibility that a crime was committed and you may have committed said crime, then I approve the arrest. But then I go ahead and get your case set for preliminary.
They mute him pretty quickly. When he's yelling, they mute him. He's gonna start to yell, but I think he'll be all right. I don't think he gets terribly loud before they mute him.
Hearings so that you can have actual evidence with representation, if you want it, for a probable cause finding with
Judge. But I'm not playing anything because, first of all, I was on my own property at my own house, and I had to explain to somebody that she has no jurisdiction in what I do over my house, or even in my house or on the property or whatever. And she called the police on me, and then the police came on my property and said, I don't know what you're here for, but with all due respect, I don't want you on my property. And then they said that, well, we got a call that said that you were being violent and that you were threatening. And I said, well, that never happened, and you don't have to talk to me. You can talk to her. And so anyway, they ended up coming up on the porch, and I opened the door again. I said, I don't want you on my porch. And they said, well, we need to talk to you. We need to
Heather,
find out, And I said, well, I don't know what you're talking about. I'm not violent. Wasn't violent at all. And so he said, well, she wants her keys. And so I said, oh, well, okay. Well, so I gave him the keys. So I gave that dude the keys so she could have them, but she could have came in and got the keys anytime she wanted to, because there are no threats. So anyway, the police officers after I gave him the keys, he opened the door and said, well, now I'm going to have to arrest you. He said, you're under arrest for threatening. And I said, I don't know what you're talking about. So I closed the door and I went the opposite direction. This dude kicked in the door and shot me in my back with a taser that burnt my back. Do that again, Judge. Do that one more time. Put the pin to the camera like you did. Did you switch something?
Nah, Mr. Seahigh, I did not. Mr. Seahigh.
Okay, well, anyway, that's what it is. And they ended up taking me to this place that I'm not supposed to be at because of how you and some other judges and other people abuse me in here. And I really appreciate being in jail. And I want to let you know that you know for a fact that I'm the one that gave those videos out, and I reported how those babies were getting killed and blood was being spread all over the wall. I mean, you've seen the video. You admitted you did on the other court dates. So what is this, Judge? Are you against me having my own property? Are you against me exposing everybody for killing kids? For and on the record.
Mr. Seahigh, all I'm doing today is
Please stop moving your hand to the camera. You're doing that intentionally.
No,
stop doing that.
No,
you were told that I'm not supposed to be in this jail. You know for a fact I'm not supposed to be here. Where's the evidence at? For and on the record.
Turn off the audio now.
Yeah, that's it. They're going to continue on with the hearing. It still lasts for another about 5 minutes, and he's going off. So that's why I said I don't think he gets too loud before they mute him. But now I guarantee he's yelling at the top of his lungs because we are going to watch him go off. All right, let's go.
Mr. Seahigh, in count 2, you're charged with battery against a law enforcement officer, a Class A person misdemeanor. If convicted, it's a maximum of 6 months, $1,000 fine. In count 3, you're charged with interference with the law enforcement officer, resisting arrest. If convicted, it's a level 9 non-person felony. In count 4, you're charged with threatening a police officer, Cody Marvin. It is charged by the prosecutor's office as criminal threat, a level 9 person felony. If convicted, you could receive 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. I imagine count 2 through 4 are incidents that are caught on camera, as most of the officers wear body cams. Probably not count 1. That will have to be the statements of Shannon Seahigh as to any reporting of any threatening statements by you or actions by you. I'm going to enter not guilty pleas on all of the charges. I'm going to schedule this case for an immediate preliminary hearing at the first available date I have, as well as I'm going to review the
Jabbergear's hair doesn't grow. It's always that length. And, he's an android. His hair's not going to grow. Boom, proved you wrong. Unless you can somehow prove that the guy in jail is an android, then neither one of them have a barber. So if both of them have no barber, can that be considered the same barber? I don't think so. I submit that it cannot.
Probable cause affidavit that should be submitted by today by the prosecutor's office for e-filing, so that I can determine whether or not they had probable cause for an arrest, and then give you a full hearing on May the 28th at 10 a.m. Now I'm going to set bond for you, and I'm going to ask for a recommendation from the state.
Yes, Your Honor, and the state is recommending a high bond in this case, as may be determined by the court. As part of special conditions, the state would be recommending no contact with any endorsed witnesses or alleged victims, that the defendant can take prescription medication and no drugs or alcohol. I believe the court has already indicated some familiarity with the defendant on the record here today. Additionally, this appears to be a defendant with a history of adjudications and convictions the court may consider relevant. Disorderly conduct and at least 2 battery against the school employee adjudications, as well as convictions for disorderly conduct, misdemeanor assault, domestic battery, criminal restraint, and felony interference with law enforcement. Pursuant to the affidavit, this appears to be a defendant who attempted to barricade himself within a residence, as well as threatened to kill multiple individuals, including at least 1 law enforcement officer. And it would also appear that there is another Butler County case.
Okay, bye.
Butler County 21 CR 457, which does appear to involve a journal entry of judgment of direct contempt of court signed by Chief Judge Rickey. And in that case, it would appear that the defendant was convicted of battery, in which the victim was a detention deputy.
Okay. I'm sorry, what was the amount that you're recommending?
Your Honor, the state is prepared to defer to the court as to an appropriate amount. Certainly, the state would not be opposed to a $7,500 cash or surety bond. However, given the particular facts and the history of this defendant, the state does respectfully suggest a much higher bond is appropriate.
Okay, well, I'm going to set his bond at 10,000 cash or surety with GPS. Absolutely no contact whatsoever with Ms. Seahigh, and I assume she still has his child, but I don't know. I'm actually surprised if they were in contact or living together. If he had remained attentive and didn't leave the room here this afternoon, I would have asked him for any statements he wanted to make about bond. And I probably would have asked him about his living situation and any potential no contact orders with Shannon Seahigh. I'm going to assume, since he's not charged with violating a no contact order of any kind, that they were allowed to resume cohabitating, either as he flattened his time or his probation expired or someone lifted no contacts. It's been a while since I've had any cases with Mr. Seahigh. My cases with him were disposed of rather quickly, but at any rate, that's the bond. I gave him an expedited, this is actually a preliminary hearing, not a control setting. I don't know if Mr. Watts will have a conflict with representing him. It seems like maybe Mr. Favre has been his attorney previously. So if Mr. Watts does, he can forward the case to Mr. Favre.
And Your Honor, what I would tell the court is that journal entry of sentencing in Butler County 21 CR 457, it would appear that that journal entry does make reference to Mr. Favre, and in response to the court's earlier inquiry, it would appear that the court did order 6 months in jail, but that the defendant was awarded credit for time served.
Okay, so essentially flattened his sentence. Yeah. Okay. Now, these preliminary hearings are in person. So he's to appear in person, and at least he won't be aggravated with my pen because he won't be able to see anything in my hand in the courtroom when I'm on the bench. But
come on, Regier, that was a joke. Just a half smile? Come on, something. Give us something.
Historically, he's failed to come out of his cell. And I don't know if he has a history of failing to appear if he makes bond, but we will deal with that if and when it happens. But this is, as I indicated, evidentiary hearing with witnesses in my courtroom on May the 28th at 10 o'clock. Okay, we are adjourned.
And Your Honor, just to be clear, the court is appointing Mr. Watts to this case?
Yes.
Thank you, Your Honor.
He will transfer it to Mr. Favre if he needs to. And I'm pretty confident he'll want to if he has a reason to. Thank you.
Thank you, Judge.
That was joke number 2, Regier. Come on. Come on, Regier. Yeah. Doreen, I think you're right. They forgot to upload the Grin program. All right. That one was fun. Let's see. Wixom had a question. I started. Yeah. Yeah, actually I am. I'm gonna be up there for I want to come up for Lindsay Dineski's actual preliminary exam, and I feel like that's real soon. I need to go. I don't have it written down. It's in a text. I got to go find when it is, but I want to come up for that. I want to say it's as early as next week. Why do I have the 29th in my head, and I don't know why. Anyways, that's the idea. I'm gonna try to. I want to come up for her preliminary exam in circuit court. I think that's gonna be a train wreck. That yeah, I do not want to miss that. So that's at least the idea. All right. Let's see. Dave, thank you so much for the gifted membership. I appreciate it. Welcome to the new member. Thank you so much, Dave. That is awesome. All right. Right? Always laugh at the judge's jokes. Do I have a shonen knife in my head? Probably. Okay, let's move on. So I told you last night that I had 4 Judge Simpson, Mr. Allen clips. I only played 2 of them last night, and I said I'd play the other 2 tonight, so I've got them for you. And that is how we're going to end the evening. Got 2 Mr. Allen Judge Simpson clips, both of them from yesterday. So let's go.
Thank you. Court calls the case, People versus Victor Morris Gerard.
On behalf of Mr. Perhaps state your name for the record.
Victor Morris Gerard.
Your Honor, in regards to the probable cause conference, we're requesting an adjournment. There was still some outstanding discovery that we requested.
You have a green sheet? No.
That's a no. I've got it right here, though.
I don't mind it now, but we do have a problem. Conference 2025. As to the bond violation.
As to the bond violation, and I did have an opportunity to speak with Mr. Gerard. He takes full accountability. He's indicated to me that he has been struggling with depression, and obviously now knowing that this issue is much bigger than we talked about treatment opportunities. In the report from they did indicate that they have made a referral for CCOP on his behalf as well. He has not spoken with Mr. Brown to see where they are with that program, but I just asked the court to at least give us the opportunity to explore that option and see if we can get him into outpatient treatment.
No, you might be able to get him into outpatient treatment, but he's clearly in violation because they have had 4 successive tests where he's positive for cocaine, amphetamines, and then his last test positive for cocaine and alcohol. But before the confirmation test on the alcohol, he left the building.
And I did ask him about that, Your Honor. I think that was just a misunderstanding. He stated that he did not know that they needed him to stay in the building to do any other follow-up tests. But I've explained to him that once there is a positive alcohol test, that they require the confirmation test.
All right. Anything else?
Nothing else.
So I set it for May 6th, 9 a.m. But at this point, defendant's bond is revoked.
Thank you.
Court calls case, People versus Justice.
Yeah.
Court does call the
that
case of the People versus Derek Stewart.
Yeah, I've got nothing to say about that. That's why I didn't even put the next case divider in there. Like, I don't even want to talk about that case. Get him, Mr. Allen.
And Your Honor, Alexis Pluma, I'm appearing on behalf of Mr. Stewart, who is in the vestibule right now.
Wait, did you? Which Stewart?
It's Derek Stewart.
Yelling. Who's that yelling? No, who's yelling? Why were you yelling?
I didn't hear the first name.
Talking about
And Mr. Stewart, could you state your full name?
Thank you, sir.
Your Honor, our office has received a copy of the competency evaluation in this matter.
I've got fruit snacks. I bought a bag of fruit snacks. I don't know why. I was at the store, I think on, what is it, Monday? And I was walking through the candy aisle because I don't know why. I usually choose the chip aisle to walk through to go to the cash registers, but this time I chose the candy aisle, and I just walked by a bag of fruit snacks. Like, you know what? I don't know why I'm going to get them. I haven't opened them. They're still sealed, so you can have them. They're all yours. Then you don't have to drive. Well, but I'm not going to come give them to you, so you would have to come drive. So yeah, you know what? No fruit snacks for you. Sorry, I can't help you. Sorry.
Have gone over it with Mr. Stewart, and we are not objecting to the findings of that report.
I am objecting. That the defendant at this time is incompetent to stand trial, but with treatment would likely regain competence within a statutory period of time.
Yes.
Any other additional evidence from either side?
No.
I need it 3 months because excuse me. Set a competency review hearing July 24th, 2025 at 9 a.m. Counsel, you'll prepare the requisite order.
Yes, and Your Honor, if I could briefly address bond.
Yes.
So I for whatever reason in on-base, I'm not able to find the most recent community corrections bond order. But Mr. Stewart is on some kind of a GPS tether at the moment. I'm not sure if it's just tracking or if it's an exclusion zone. That is both very uncomfortable for him, and because he currently doesn't have housing, it's very difficult for him to make sure that it's charged to get somewhere where he can plug it in. I will note that he has been, at least the last few times that I've represented him, he has appeared on time for court. Nothing, nothing by way of new offenses. He's compliant on bond. He would just ask Your Honor to consider removing that tether.
Right. Any response from people?
Your Honor, I understand it may be uncomfortable, but unfortunately, the nature of these allegations seem to require it. Mr. Stewart is charged.
I'm disabled. What am I?
Pay attention to the judge. Ooh, Mr. Allen, pay attention to the judge. Yeah, he turned towards Miss McDuffie, and Mr. Allen's like, nope. Miss McDuffie is a saint. You do not look at her. Look at the judge. Good job, Mr. Allen.
It's your world. I'm just in it.
May I continue?
Go ahead.
The nature of these allegations appear to require Mr. Stewart is charged with one count of witnesses bribing, intimidating, and interfering. Essentially, the allegations in this report describe Mr. Stewart. These are physical confrontations in terms of rushing this individual in this area. Now, him no longer living, I think, close by.
That is absolutely Miss McDuffie. I know that voice anywhere.
May assist with that, but I don't have any assurance that Mr. Stewart is going to be able to essentially not contact this person. I might feel differently if we were dealing with text messages and emails and phone calls and that sort of thing. These are physical confrontations.
Your Honor, I do believe Mr. Stewart is no longer living at that location. This incident occurred back in 2022. At the time, I believe Mr. Stewart was still at that apartment complex. He had since been evicted and isn't staying there anymore. It's my understanding that you are usually in downtown Ann Arbor, or Delano's Center as his mailing address. Okay. But either way, I don't think he plans to or has been going back to that location.
Well, you evicted me, why should I go back?
All right, the original order, that's what may help, is, at least as I see it, the original order was back on September 21st of 2023. However, there was a period in time at which, for whatever reason, as it was proceeding, it came through, and then I think at some point the defendant bench warranted, and there were some other issues. At later date, I then set aside the bench warrant, reinstated his previous bond conditions, which is why he has the tether on now. Okay. So I'm a bit reluctant. Well, what I'm going to do is this. I'm going to deny your request at this moment. And what you would need to do is file a written motion that I can consider fully as to the release, where he is, and lay all of that out to me. So at this time, the motion for bond modification is denied. Thank you.
Okay. Thank you.
And when
Bond will continue.
24th of July?
Yep.
All right. All right. That's about it. That is about it. I do have one thing I want to share from our good friend Rich. You know, I've done this multiple times and it still takes me a second to remember what buttons to press. Here we go. Rich, thank you so much for putting this together as always. And a massive thank you to all the super chats, the gifted memberships, and the membership milestones. You guys are awesome. Jedi, Dave, Phil, Darina, Legal Fiction, Sparkle Potes, and Elisa Molina and Liberty Bell. Thank you so much. I do appreciate it. You guys are awesome. But speaking of, I just pulled that up and I didn't even call out the last two. Phil, thank you so much. In case Rich thought he was done. Did you make it? No, Phil, you're on there. Yeah, you're on there, Phil. He got you up there. So I'm guessing, yeah, Sparkle Poots. Sparkle, thank you. I do appreciate it. You guys are awesome. But yeah, that's the show. That is the show for the night. I do appreciate you guys stopping by. Hopefully we get Big in tomorrow. I've missed that guy for 2 days. You don't realize how much you miss something until it's not there. Like, man. So hopefully he gets his tech issues fixed and we get him tomorrow night. Speaking of tomorrow night, I am most likely going to be streaming tomorrow night. Heather and I moved date night to Sunday night. She has plans tomorrow night, so we moved it to Sunday night. So I'm not streaming Sunday night, which means I'm most likely going to stream tomorrow night. Saturday, like tomorrow, I'm going to be doing a lot of work trying to get everything together for Heather and I to work on the new intro and everything on Sunday. So that shouldn't take all day. I should be able to put a stream together still. So yes, I will most likely be streaming tomorrow night, but absolutely not Sunday night. Sunday night is now date night this week. So yeah, there's that. Legal Fiction, you made it. You made it, bud. Thank you so much. Thank you so much for the super chat. All right. We're going to raid Lone Wolf tonight. I know KFAR and KDZ are doing their thing tonight. I raided KDZ on Wednesday and KFAR last night, so I'm going to go ahead and raid Lone Wolf tonight. But like I said, KFAR and KDZ are both streaming, so you can go jump over there. You can go jump over to Lone Wolf. Yeah, it's not going to bother me which one you go. All three of them are awesome. So yeah, wherever you go, tell them I said hello, and you guys have a great weekend. If I don't see you tomorrow night, have a great weekend. Don't do anything dumb. You don't want to end up on my channel. Trust me, you don't. The chat's going to make fun of you more than me, but the chat will. All right, you guys are awesome. Thank you so much. I will see you tomorrow night. And yeah, that's it. Until next time, bye.
Huh? Oh, is that what it is? Okay. I don't know what it is.